on a pre-plan of, this was in anticipation of this presentation today, assuming we hadn't reached agreement. But at the time, our county prosecutor in Cuyahoga had determined that he was not going to comply and was going to let the Ohio Supreme Court decide it, since he felt that it was inconsistent with Rule 16. Are you aware at this point of any appeal? I am not at this point on that.
I thought that it was heading.
Okay, it may still be heading that way. We're not aware of that case yet, but we'll see where that works out. So far, obviously, our prosecutor has been complying. In Ohio, just so we kind of get the magnitude of it, 88 counties, 41 of them, per our study, have some form of open discovery. Now, that may mean that the county hub does not practice open discovery, but there are certain municipalities that do within. So there is an open discovery entity within 41 of 88 counties. Excuse me, and let me go on. I'm sorry, that's at some point just about the majority of them have open discovery. In fact, 82 of them, if you look to the municipal courts, we counted 250 courts in Ohio have kind of practiced it on their own informally and without teeth.
Well, and I would just add that the maximum exposure in municipal court, even if you have multiple charges, is 18 months. Typically, they're petty offenses. They're going to result in a few days in jail, and you very rarely have gangland, drug trafficking, and those kinds of cases that have any implications in municipal court. So it's obviously helps to expedite the system in municipal court.
On the national perspective, and that will obviously be the next step, the NACDL, the National Association of Criminal Defense Lawyers, are now talking and kind of watching what happened in Ohio. There was a school of thought that Ohio was one of 3 states that would be the most difficult to get reform. And now that we have reached agreement, there is discussion to this moving onto to a national debate. But what we have are 22 states, and I don't know if I captured it all with the blue. I apologize. 22 states have some form of open discovery. Of the 22 states that do, yeah, I didn't capture them all. But of the 22 states that do have them, none of them have reverted back or limited it in any way or decreased it in any way. This was the next clip I put in for David. I told you I did have to pay my respect, so it is no longer the original slide. And what I want to do is talk about the joint proposal. Now, we're not able to, upon agreement, release the rule yet because it's got to go to the court first. But what we are going to do is kind of go over it. You'll be the first to hear about this rule as we go forward. I will say that purists on both sides are not happy with the rule. There are folks in David's camp that felt Rule 16 was fine the way it was, and there are folks in the defense camp that are saying, look, it's the defendant with the rights, and we shouldn't have to give over anything, and we should get everything. And we had met several years ago with members of the Rules Committee, representatives of the court, and most recently with the legislators that were involved in this matter, and the common thread throughout was compromise, 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 or this wasn't getting done. And so that's why we really had to come together to understand what the issues were. The very first thing that you will see in the rule, which would be subsection A, it's purpose, scope, and reciprocity. All right, reciprocity, now there is a reciprocal obligation on defense counsel. A lot of the states that practice open discovery do, in fact, have a reciprocal obligation with qualifications. It's not that we give over everything. Obviously, you have to honor work product and attorney-client privilege, and you cannot turn over inculpatory material. So we'll go over exactly what that means. But we made it very clear that this rule is to provide all parties to criminal litigation with a full and fair adjudication of the facts. And we put out specifically who that was. And the first is we have to honor the rights of the defendant, of course. But we also want to make sure that witnesses, victims, and society at large are protected, and so that is placed all parties in the opening provision. Dave? All right. And there had been kind of through this process, we had gone through the process, we were at, give everything, started as everything's fine. There were suggestions made throughout, and most recently I've gotten a lot of calls saying, well, are we doing the Summit County model where it's inspection? And we have agreed upon that for the most part. And again, we're talking about 90% of the cases, we will have the right to have all of the evidence, police reports, witness statements. So it's right to copy or photograph is what we've agreed upon a written request for discovery. So what we will get, any written or recorded statement by the defendants, co-defendants, including police summaries of such statements, including grand jury testimony of either defendant or co-defendant, obviously the criminal records, labs, hospital reports, physical, mental exams, all of that. All police officer reports, provided, however, that a document prepared by that person will not be considered to be their statement until it's been accepted by that witness during examination. That is kind of the rule now, and just pursuant to the rules of evidence.
I might add, to just jump in here a second, in the past, the debate has been about giving over police reports. The rule is actually going to use a broader term, peace officer reports. So any one of that long group of people that is listed in the statute as a peace officer, which includes your transit cops and your college cops and all those sorts of people, are also going to be included, that those documents are discoverable.
And that was an important point that came up, because the distinction under the code, or the definition, I believe, was for peace officer. So the question was asked several meetings ago in Columbus, who exactly are we concerned about? And this gets to that 10%. And one of the issues that the prosecutors had was that they have to retain discretion, and retain discretion to make sure that their witnesses, victims are safe, et cetera, as Dave had spoken of a minute ago. And so this is where the rule gets interesting. And this is where it differs from what we have right now, even more so. I kind of look at it as a tiered system. And I'll let you kind of talk about, we call it designation of, well, let's certification aspect.
Certification. Well, I think it might be helpful, Ian, if we made a list here of the levels, as you were. The default, it's not a very good marker. The default position of the rule is basically everything gets turned over. And that's consistent with both sides' agreement that in most cases, I got a bad check case. I've got a felony for possession of narcotics case. We've got an aggravated assault case. There isn't anything in my file that I don't want you to see. In fact, it's probably going to help me get a plea if a plea is appropriate. Or we're going to figure out real early that trial is necessary. But there are a limited group of cases, and the prosecutors were just, and this has been the stumbling block for 20 years. What does the prosecutor do when they've got that key